All right, 3, 2, 1. Good afternoon, all. Welcome to today's webinar, 23 NYCRR Part 500, What Lies Ahead for 2018. Today, your hosts, Synoptic and Harder, Seacrest, and Emory, will bring you two unique perspectives on the upcoming NYCRR regulations. Harder, Seacrest, and Emory will provide guidance and insight on the legal side of the regulations and also speak on what you need to know to be compliant. Synoptic will provide advice on the security house of the regulations, getting into detail on the exact specifics that you need to know to be compliant from a security perspective. A few house cleaning items before we get started today. If you have any questions at any point in the webinar, please enter them on the box, the lower left of your screen, the Q&A box. We will address those in a live Q&A session at the end of today's webinar. There will also be a recording and the slides will be provided to all of today's attendees. All right, let's introduce today's speakers. Paul Green is partner and the chair of the Privacy and Data Security Practice Group at Harder, Seacrest, and Emory. Paul's practice centers on cyber breach preparation, response services, as well as complex industry-specific litigation. On the Synoptic side, we have John Avery, Information Security Director. John Avery provides cybersecurity consulting, including strategy, implementation, and remediation to firms that have strict security and compliance requirements. To get things started, I'm going to pass it over to Paul. Paul, over to you, sir.
Great. Thanks, Tyler. And being the lawyer on the call, I just wanted to start by noting that my comments today are not legal advice, but we do want to orient you to the various concerns and issues that arise with Part 500, especially since we're in its second calendar year of implementation, and we've got some new requirements that have come on board, as we'll see in just a minute. So here on this slide, I wanted to kind of level set and just reflect on the background of Part 500 a little bit. It's interesting for a number of us on the call, Part 500 may seem like old hat. We've been living with it for just a little over a year now. But this is a new regulatory scheme. It came on very recently, and that's really part of the problem. There's not a lot of history here, not a lot of experience on which we can base our expectations of future enforcement or interpretation. So, here's the background. It was made public back in 2016. Some of the steps in the slide we'll discuss a little later when we discuss the fact that this is a different animal because it's a state regulatory animal. These are a set of rules created by a state regulatory agency, not a legislature. And that brings with it a whole host of different concerns that we'll address in a moment. But first made public back in 2016, revised. That was interesting. Not many people expected DFS to revise their draft regulations, but they did. For those that were following the issue, the initial regulations were very prescriptive. It told us what to do and how to do it. And the response from the industry was, well, hey, a regulator should not be telling me how to secure my systems. I'm the one who knows best how to do that. Give me more flexibility. And that occurred in the first revisions that took effect in December of 2016. Again, they were proposed regulations at the time, so this was all part of the promulgation process. And in those changes, the state made the vast majority of its requirements under Part 500 subject to the risk assessment, which has now come online as of March 1 of this year, and we'll discuss that in detail further in the webinar today. So they came into effect in March of last year. There was a 180-day grace period and expired in August. And we'll be discussing the other transitional periods here, 1 year, which just ran as of March 1, 18 months and 2 years. On February 15th, there was a self-certification deadline. There are new requirements as of March 1, as I mentioned, but the self-certification deadline is important Because if you didn't file a self-certification, DFS is now sending out emails to thousands of individuals and entities in the state saying, hey, you didn't file, where is your certification? And sometimes DFS is getting these notices right, sometimes it's getting these wrong. It's causing a lot of confusion in the industry, but those notices are indeed going out. Okay, so next slide. I mentioned the notices in relation to DFS. These are new regulations. DFS is at least trying to be in the 20th century by keeping its communications electronic. And here are some of the platforms on which it wants to have those communications. You've got the DFS landing page. That's got information about the regulations generally. The regulations are there. There's also a link to the next two bullet points I have here, the FAQs and the portal. That's all on the landing page. Interestingly enough, when DFS started sending out these emails concerning self-certifications, they got a lot of questions because they did get some of the emails wrong. And they put their directions and their clarifications concerning the email on the landing page. One would have assumed that they would have put it on the FAQ page because they were being frequently asked certain questions in relation to the email. But the guidance appeared rather on the landing page. Very granular issue, but if you're governed by Part 500, you've got to keep your eye on all of these balls to figure out where DFS is going to give you guidance in relation to Part 500. The FAQs are very important, and they've been revised a number of times since they were first put up a number of months ago. There are currently in the teens of FAQs that are up online. The most recent edition was just a few weeks ago. These FAQs are part of a continuing phenomenon with cybersecurity regulators that they like to give regulatory advice via the web. And that's nice because it makes it readily available. It's not so nice because there is no notice to you by way of an email or a letter going to you directly. You've got to follow this page, set up a Google alert, watch for changes on the page because DFS may make guidance available that changes how you should have your compliance program structured. Very important page. Then there's the portal. They want all reporting to happen through the portal. Interestingly enough, and unexpectedly, the portal survived the onslaught of self-certifications that went in on February 15th. To my knowledge, it didn't go down. I haven't heard any complaints in that regard. So they did build a robust reporting portal. But like every web link, it can go down from time to time. So if you need to use it, make sure it's there when you need it. And then who we supervise. For those of you who still don't know where DFS fits into your the outlook of your organization, that page has no less than 6 separate links where you can find listings of entities and individuals regulated by DFS. All covered entities should be listed there. If you're listed there, you're very, very likely covered. So what was required as of August of last year? We've got the requirements here. Most importantly, the first 3, cybersecurity program, the cybersecurity policy, and the CISO. Everything else kind of flows from that. But to really sum it up, the state was looking to be sure that covered entities under Part 500 had a program in place and had implementing policies under that program and had an individual who could lead the charge in that regard. Access privileges is really it's a 2-3 line requirement in the regulations that basically says that a covered entity shall appropriately restrict access to protected information and networks and review such access from time to time. So very common sense approach, something we are likely, most of us doing already even before, or have been doing even before Part 500 came around. Cybersecurity personnel intelligence certainly DFS wants you to have appropriate people in place. They can be internal or external. This, like the CISO role, can be outsourced. And that's key. If you don't have the resources or personnel internally, you should certainly consider working with someone externally for the CISO, a virtualized CISO, or a virtualized information security department, because DFS gives you the option to do that. And then lastly, notices to superintendent and incident response plan. These are two important issues. DFS wants to be sure you've got an incident response plan in place and that you know when and how to give notice to the superintendent arising from a breach. Okay, so I mentioned, this is a new animal. It's a regulatory beast, and that's a little different. There's no public discussion, really. There's no argument on the legislature floor. There is some lobbying, not as much as with legislators. But the most important thing about a regulatory scheme is that it's subject to change pretty quickly. I mentioned all those notice and comment periods before. I ran through the timeline. Within 45 days, the state can create a new set of regulations. And in fact, we'll get to this on the next slide, they can do it even quicker than that. But here we have an administrative agency reaching out based on its generalized powers, those sections that I referenced there in the second bullet point under the Financial Services Law, to create cybersecurity regulations. Arguably, as a matter of administrative law, DFS has gone far beyond its own powers in creating these regulations. I doubt anyone is going to sue DFS on that front. No one really wants to be the poster child in the financial services industry to say, I don't think I should keep my data safe, because that's how it will look if you sue DFS in this regard. But they have extended pretty far, and extensions like this, specifically in relation to the FTC, have been upheld in the past. So I think Part 500 is here to stay, but it may be on iffy ground, and it may not well be challenged. So I mentioned the regulatory piece of it. Keep in mind in the timing issue, here we have a bureaucrat in charge, the commissioner of the Department of Financial Services, but also the executive, the governor of the state of New York. Keep in mind it's an election year. What points can Mario Cuomo win in relation to cybersecurity regulation? That is a reality we need to keep in mind as we look at these regulations. And here we have some of the timing issues. 45 days for new regulations and an emergency regulation, which can be put into place, change the entire regulatory scheme on no notice whatsoever, can be good for 90 days and can be extended almost indefinitely. As long as the emergency that the state identifies concerns public health, safety, or general welfare. Keep in mind, general welfare can also mean economic welfare. So if there's a huge cyber attack to the financial services industry, DFS can change the rules from today to tomorrow. New infrastructure, I've talked about the portal. I have here that it hasn't been stress tested. Well, maybe it has, given the recent self-certifications that went in on February 15th. But if you've been logged onto the portal, you'll see that the field in which you put your entity's name to give a report is self-populating. So if you have a word or name in your entity's name that is common, that's going to bring up a host of different entities that you can report on in relation to. I am sure that there was some human error involved in the recent self-certifications, and there's likely to be some in the future. We don't really know how the regulators will interpret the regulations. Some DFS regulators are analogizing them to something that may be familiar to a number of folks on the call, the FFIEC guidelines for federally regulated banks. That's good news because we would really like to see DFS following in the footsteps of other regulators, not recreating the wheel. But there's no guarantee that they'll stay or continue on that path. And no one knows what the follow-up will be. There is no specific section in Part 500 for penalties or investigations. Rather, DFS has given itself or left open all of its options, which include things like an administrative subpoena or even in-person investigations, audits, examinations, that kind of thing. fines, and delicensure. So no one really knows what the follow-up to any outreach from DFS will be. Okay, I'm going to quickly go through three or four elements of the new regulations that I want you all to keep focusing on. The first is the definition of NPI, non-public information. Now keep in mind, here's the red bullet point at the end, DFS NPI is not the same as Gramm-Leach-Bliley NPI. If you're a financial institution, you should know Gramm-Leach-Bliley NPI that is similar but different, similar to but different from New York State DFS NPI. And here are the differences. The first category, information the compromise of which would have a material adverse impact on the organization. That's not in Gramm-Leach-Bliley. Neither is healthcare information. The PII, generally, that is generally covered by Gramm-Leach-Bliley as long as it relates to a financial transaction. But DFS does not limit their PII to information you get in relation to a financial transaction. So it can mean your employees' information. DFS NPI is much broader than Gramm-Leach-Bliley NPI. So cybersecurity event, this is one of the most controversial terms in the new regulations when they were first proposed. It remained unchanged. And that should tell you that this is a very important definition to DFS. They're not going to budge on this one. They got a lot of commentary, negative commentary, but they decided to keep the definition. And here it is. It includes unsuccessful attempts, and it's any attempt to access, disrupt, misuse an information system, i.e. your network, or data on that system. Not even NPI, not even protected data, just any data on your system. So this could be a ransomware attack, successful or unsuccessful. Could be a denial of service attack, successful or unsuccessful. Could be a straight-ahead hack or a phishing attack, social engineering. Now keep in mind on those FAQs that I mentioned before, DFS came out with a very, very helpful one saying that it didn't expect or anticipate that unsuccessful attacks would be reported in the ordinary course. The majority, it said, would remain unreported. And that's good news. DFS looks like it's going to defer to us in our good faith assessment of whether an unsuccessful attempt should be reported. We'll talk about that reporting threshold in a moment. But if you look at the definition of cybersecurity event, this can include really millions of hits on your firewall and IDS, IPS system a month. So you've got to have a system in place that makes automatic your assessment of these events and lets you know when a material one occurs. Okay, so here's the notice issue, when we give notice to the superintendent of what I call a material cybersecurity event. And a cybersecurity event is sufficiently material for notification whenever it has a reasonable likelihood of materially harming a material part of your normal operations. You need to use those definitions in your risk assessment really defensively. Make sure you know what a reasonable likelihood is for your organization, what material harm is, what the material parts of your normal operations are, so that you can set that bar high so that the 72-hour clock of notice to the superintendent does not run before it really should. And it's entirely proper to use those definitions defensively. Otherwise, you'd be inundating DFS with reports and notices when you don't necessarily have to. Also, I can tell you from years of experience as a breach coach, within the first 72 hours, you really don't know a darn thing about your breach, and what you know is probably wrong. So if you're reporting too early, you're probably giving the wrong information, and you're having to supplement that later on. And that can just create complexity, if not problems, with your regulator. So here again, this last bullet point, you need to scrub through all of those very generic cybersecurity events, which could include every firewall deny, to determine which ones qualify as reportable. You need an automated system or an appropriate system to do that. Okay, cybersecurity program. If you're under Gramm-Leach-Bliley, which many on the call likely are, here's a question. Is it the same or different from your written information security program required under the safeguard rules of Gramm-Leach-Bliley? Well, there are different requirements. my approach with clients is to make sure they harmonize the two. Don't have two programs in place. Just make sure your program addresses both Gramm-Leach-Bliley and DFS if you're subject to both. Now, does the C matter? Do you need a separate program just to show that you have a cybersecurity program in place? Do you need it to have that title? Well, you better know where to find it, at least, when the regulator comes knocking, because if you have to explain that, no, my WISP is my cybersecurity program, it may take a while to actually explain that. And what's in the cybersecurity program? Well, it generally follows the NIST cybersecurity framework. It's got the 5 steps in the CSF that I've noted in bold there: identify, protect, detect, respond, recover. It also has one that it's added, a very important one: fulfill reporting obligations. And that's not just reporting to DFS, it's reporting under state law, for example, or following through on any other reporting obligations you may have. Next is the CISO requirement. Again, does the C matter? Well, the revisions say no. There was a pushback, but because the first version of the regulation said you have to appoint a CISO, and it has to be a CISO, a Chief Information Security Officer. I'll give you an example here in our firm. Just as a matter of internal governance, we have very few C officers. We're a partnership, and C officers are kind of foreign to us. So we don't have a CISO. We have a manager of information security. And that's appropriate under DFS. So the C doesn't really matter. Just make sure that that person is fulfilling all of the obligations required under Part 500 in relation to the CISO. The CISO has to give an annual report. That's one of the requirements that comes online this year. That is available to DFS upon request. So even if you have an attorney involved in that report, it may not be privileged. DFS has a right to see it if it asks for it. The elements of the report are listed there. And as I mentioned, the CISO function can be outsourced, but the covered entity, your organization, bears the ultimate responsibility of governing that CISO and making sure that he or she is doing the right thing. And keep in mind, what about the CISO's backup? What if the CISO gets the flu or is in Aruba for a week? Who's going to pick up the reins of the CISO when he or she is away? Self-certification, I've talked about that a little bit. It needs to be by a board member or the senior officer. I really recommend that it be an officer. The board is there to oversee management. Officers are there to manage. It covers the prior calendar year. You've got to maintain records for a certain amount of time. You also need to document areas that need material improvement, but that's not part of your report. It's in the reporting section, 500.17, but it's just something you need to internally document and keep for yourself in case DFS comes asking for it later on. So some defensive strategies. I've touched on these already. Use these definitions to your advantage. NPI, defining what has a material adverse impact on your organization. Set that bar high. Reasonable. You don't want to really game the system. But you want to make sure it's set as high as reasonably possible. Otherwise, your risk assessment is going to be skewed, and your policies and procedures are going to be too tight, overly restrictive. Use your risk assessment to your advantage. Risk assessment is one of the requirements that's come online this year. That is really the baseline for everything you do in DFS. To my mind, it's the baseline for everything you do in relation to cybersecurity, whether under Gramm-Leach-Bliley, HIPAA, DFS, GDPR, under any of the state laws like Massachusetts that require a written information security program. The risk assessment is key. And consider using the attorney-client privilege. The risk assessment is like making sausage. There is a whole lot of stuff that goes in and hopefully something good that comes out. There are judgment calls made in the risk assessment. And as a litigator, I can tell you, if I were suing a company that had a breach or some adverse security issue, I'd be asking to see their risk assessment, which is a roadmap to those judgment calls that the company made. And those kind of roadmaps are exactly what attorneys and regulators want to use to raise issues and raise questions. Okay, so here is a little insight into what DFS has been, or how they've been interpreting Part 500 in practice. We have access to a number of day one audit letters. This one concerned a very large organization, so at the high end of the scale. But I think these concerns do filter down. The first one's an important one. Here's a rhetorical question for everyone on the call. Does your organization budget for potential breach response? Well, if not, you probably should, because you will have a security incident in the next year, in the next budget cycle. Query whether you've got appropriate money set aside to deal with that and deal with this disruption that arises from it. Well, DFS is asking at least large organizations about this, so it certainly is something to keep in mind. Discuss and describe changes to the security threat landscape. Well, this is interesting. Certainly large organizations need to be a bit more, have a bit more foresight in this regard. They've got more ability to engage in cybersecurity intelligence. But smaller organizations need to stay up to speed on threats as well. Who's responsible for the CISO in his or her absence? Well, we've talked about that already. And provide a copy of all policies and procedures concerning vendors under 500.11. Well, we're going to see in just a slide or two, 500.11 doesn't come online until 2019. But DFS is already asking large organizations, show me how you are in compliance with this requirement that doesn't come online for another year and a half. Okay, very quickly, here's a listing of what's effective as of 3/1 of this year. CISO report, that means sometime in the calendar year you need to do that report. Pen testing, vulnerability assessment, the risk assessment that we talked about, multi-factor authentication, and appropriate training. Here's what's next. As of September 1, you need to button up your audit trail processes, specifically concerning your ability to respond to a data breach. Application security, to the extent that you develop or buy your software. You certainly fall into one of those two buckets. You need to assess application security. Limitations on data retention, that's a hot topic in cybersecurity regulation generally. You should only keep what you need for as long as you need it, and no longer and no more. Monitoring of your system for cybersecurity events, and encryption, both at rest and in transit. You need to consider it and document your decision in your risk assessment. And then 2 years, the last requirement comes online, third-party service provider security policy. This is going to be the big change in the industry. All vendors serving the financial services space will be subject to certain minimum standards that the FIs will put in place. Part 500 doesn't define what those minimum standards are. That lets the FIs do it. But there is going to be kind of a marketplace push for a certain minimum, and my guess is the full slate of requirements under Part 500 is going to filter down to vendors and become a new floor for those that serve the FI industry. So that's all I have, and now passing it on, we'll discuss some of the more detailed requirements coming online.
Paul, thank you so much. Very much appreciated. Such good information. So I'm going to go ahead and shift gears a little bit and talk a little bit more to the upcoming rules from the 500 series regulations. Starting with, of course, 500.06, the audit trail. This requirement pulls directly from the results of your risk assessment exercise, and you'll need to identify and categorize the system that interface with material financial transactions. And this requirement, 500.06, states that you'll need to securely maintain these systems to the extent that you'll be able to reconstruct said financial transactions to meet normal operational obligations, as well as ensure that you can leverage the necessary audit trail to detect and respond to cybersecurity events as appropriate. You'll also need to ensure that your record retention policy and procedures are properly adhered to. You'll need to maintain the same records in Part A for no fewer than 5 years and Part B no fewer than 3 years. .08, application security. If your organization is developing in-house applications, then you'll need to have policies and procedures in place to ensure that your development staff are following best practices for secure code development. Arguably even more critical here is that you'll also need policies, procedures, and contractual requirements applied to any of your third-party vendors that are also developing their own applications that your organization may be using to adhere to security coding best practices and penetration tests to validate that applications are secure. Your vCISO is charged with ensuring that all of these components are drafted, adhered to, and maintained. 500.13, limitations on data retention. Other requirements maintain that we're on the hook for holding onto records for, in some cases, a minimum of 5 years. But this requirement changes all of that and tells us that we need a well-documented and thought-out strategy for disposing of our non-public information that is no longer of legitimate business use. Not only is holding onto this data beyond requirement a waste of precious resources, but so too does holding onto this data increase our risk should something happen outside of our control. This requirement ensures that we're maintaining a clean house. There's a lot of ways to dispose of data no longer in use, but I would suggest to everyone on this call that your disposal policies adhere to or at least align with NIST Special Publication 800-88 Revision 1, where 3 methods of media sanitization are outlined. Your disposal needs will vary, but always ensure that you're coordinating your disposal efforts in conjunction with the results of your risk assessment exercise. 500.14a, training and monitoring. Since Part B of this requirement was supposed to have been instituted as of a few weeks ago, I'm sure that everybody on this webinar today is done with that and is ready to tackle Part A, right? So where Part B spoke to ongoing security awareness training, which we all know and love, Part A, however, speaks more towards data loss prevention and risk-based monitoring and detection thereof related to unauthorized access, use, or tampering with non-public information. We're squarely looking at how we manage the insider threat here. 500.15, encryption of non-public information. As many of the other requirements, this requirement finds its roots in the results of your risk assessment exercise. You'll need to implement a variety of controls elsewhere, but this control speaks to encryption of data held at rest or in transit. And where encryption of data in transit isn't feasible, you'll need to implement some compensating controls to provide some measure of security, and that you aren't transmitting non-public information in the clear. The virtual CISO will need to approve of this compensating control. I'm going to go ahead and pass the mic right back over to Paul.
Great. Thanks very much. Great level of detail there. Those are very important points. So, what do we do now? We've got our new requirements in place for 2018. Here are our thoughts on this. Don't go it alone. Both legal and information security are both key parts in assessing Part 500. That reporting threshold, material harm to any material portion of your normal operations, that's a legal question, and you should really assess that with appropriate guidance, either internally or externally. Same thing with your assessment of information security and the new requirements. If you don't have the expertise in-house, certainly reach out. There is help to be had out there with skilled professionals. And the risk assessment is key. It really lets you fine-tune all of your choices, especially in relation to encryption. Whatever you're able to do or not do, whatever compensating controls you put in place, document that in your risk assessment. Don't use somebody else's risk assessment. Don't use someone else's DFS policies. There are some online from certain institutions. They won't fit your organization. You really need to tailor these exercises, risk assessment, policy, procedure generation, to your organization, or else it's just not going to work. And consider using the attorney-client privilege. That protects communications concerning all of these issues, as long as the communications are for the provision of legal advice. Very important. You get to have full and frank discussions with your security vendor, with your vCISO, and your counsel concerning these issues, and not have those communications come bite you in the end. And lastly, we've talked about NIST before. Follow a framework. Part 500 is strongly NIST aligned in relation to, certainly in relation to disposal. That's the right path to follow. In relation to the risk assessment, don't just make it up. There's a publicly available document out there, NIST Special Publication 800-30, that walks you through the steps for doing a NIST-approved risk assessment. That's all you, it really lays it all out for you. Now, you may not have the ability or familiarity to do that in-house, which is why a vCISO or a security vendor can help in that regard. But a framework makes it much easier to explain to a regulator how and why you chose certain controls and not others.
All right, thank you very much, Paul and John. Next, we're going to open it up to questions from the audience. So again, as a reminder, please submit any questions in that lower left-hand box, and we're going to address those shortly.